line of your Python AU.
You have sent some other group right now in WhatsApp?
Yeah, we have created a group of some participants who have already submitted.
Okay. So I'm closing WhatsApp from my system, okay? You have sent some other group right now in WhatsApp?
Yeah, we have created a group of some participants.
Okay. So I'm closing WhatsApp from my system, okay? You have sent some other Dr. Ravi, my screen is automatically being shared?
Yes.
Okay. So the screen sharing link is with you?
Yes.
Okay. Can you please hold on the screen sharing link as of now?
What to order?
I mean, don't share my screen as of now.
So you can stop that stream from OBS. So
Okay.
the will automatically come.
No, I don't want to take that risk. Leave it. No problem. No problem. Let it be as it is. I'll start speaking from welcome everybody. We'll hold it for some time for let the other participants to join. Dr. Ravi, did others join? How many participants are waiting right now on an average? Dr. Ravi, how many participants are waiting as of now? Okay, great. We will wait at least till 11:05 or 11:10 for how many participants total are there, sir? Very nice, very nice. I'm really glad. In that case, we will wait for some time, not even after 11 o'clock. Okay, at least 1/3 of the population should come in. Then we will start. Meanwhile, we will be the, I'll be there. I'll be clicking on one of my YouTube videos possibly, and just going through some of my initial settings. I think I'm live, and I welcome you all. Good morning, everybody. Good morning, everybody. Welcome, a very warm welcome from our side. Dr. Ravi, please be with me in the over the call. Okay. If I don't log in some way, I will not be able to see the what's happening, right? Okay. Okay. So just some time. To allow me some time. I have. So, Dr. Ravi, the participants pool, are they all students or professors or I just wanted to get some information so that I can. uh, okay, okay, great, great, great. So, do we have companies as an audience today, members from corporates or do people who are doing business? Okay, okay, okay. I have logged in, but if I log in from a system, where will I get the live button? Not system, just tab menu. I can see. Okay, menu live. All right, I am with a different system as of now. All right, so it's time, and I welcome everybody. Dr. Ravi, you are not visible, right? So can you be also visible for some time in the settings, or you don't? It's not possible. Okay, 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 okay. I understand. All right. Meanwhile, while others join, I'm just welcome you everybody whosoever has joined. I really appreciate to come sharp on time. Uh, we have something in store for you, which I believe would be uh, new to you in terms of the way I am going to deliver. You might have heard about intellectual property before, but the way I'm going to present it, I believe would be completely a new thing, so that it is understandable to you completely in easy and capturable manner. Okay, so while others come and join, I will just play a few of my YouTube videos. Okay, so which will help you uh, some get some initial understanding on the topic, and meanwhile others will join, and then we will start the lecture, my presentation today. So this is my channel, Solutions for Your Intellectual Property. You have to just go and type solutions numeral 4 URIP. This is my YouTube channel. At the very first instance, I would like to share my YouTube channel with you all. Please try and visit my website, my not website, this YouTube channel. File till now. So Okay, so this is not my today's presentation. I'm just waiting for others to join. Meanwhile, others come. Kindly have a look with this introductory video on Pateomatic.
Welcome to our
Thereafter, meanwhile, while others have joined, I will directly take you to the introductory session about today's organizers, and then we'll start what I have to present to you, different from what it is there in my YouTube content. Okay, sit back, relax, and I hope it is going to be an engaging session with all of you. Thank you for the opportunity. Let us just have a look with this video as of now.
channel Solutions for Your IP. We provide specialized, integrated, focused, and smart solutions to your intellectual property needs that ultimately serves your long-term interests that reflects in the growth of your business or research. In this video, we present to you the first of its kind, an automated method to draft a patent specification all by yourself through Pateomatic. As the name suggests, Pateomatic is patents generated through an automatic tool, that is Pateomatic, the combination of patent and automatic. Are you a doctorate or a professor or a lecturer in any university or college or institute of higher technical education? Then I am sure you must have already a list of publications in reputed journals to your credit that floods your resume. Your journal publications are truly appreciated, but then I would ask you, how many patents did you file till now? For your information, the contribution of patent applications from the intellectual academicians of our country is very scarce. It is not even 10% of the total patents filed by the academicians in foreign universities in the Western world, or even universities from China and Japan. The number of patent applications from an academic institute also speaks for its academic quality, not alone publications. Did you know that your publications are copied and combined by your smart academic counterparts or collaborators? That is in the form of patent applications. Moving further, such patent applications are taken up by companies and then commercialized through patent licensing in our country. In the process, you lose the freedom, credit, and ownership of your technical developments and also end up buying something that you might have possibly created at first. On the other hand, if you are a technical graduate, research scholar, or a student pursuing any technical curriculum, I urge you to file a patent application now and feel the difference while you face interviews for job applications and the preference given to you by your potential employers in the future. Realize the joy of conceptual learning by inculcating a habit of making new technical developments which was not present before. Yes, it is a myth that unless you have made something very much complicated, high-end technical stuff, you are not eligible to make a patent application. Let me tell you, patents correlate with the specific applications of science and technology. And yes, such an application might be even simple but new. The moment you can attribute a new element to your technical development, you do qualify for filing a patent application. But how do you make the patent specification out of your new technical development, which is necessary to make your patent application? You might not know that drafting the appropriate patent specification, being completely in the nature of a professional techno-legal expertise of a qualified patent attorney, a patent specification is the first step towards making a patent application. A patent application is filed accompanied with a techno-legal draft called as a patent specification, without which the application made by you for obtaining a patent in any country's patent office is not complete and might even result into rejection of your patent application, which is not drafted in the manner of a legal document called as the patent specification, despite possessing relevant potential and technical subject matter which was otherwise or would have been possible to obtain a patent. Hence, a patent specification is the only and the absolute requirement prior to making a patent application. It might be difficult for you to find an appropriate patent attorney who would also know your technical domain because you don't know or you do not have the time for it, or even if you find one, it definitely will be expensive for you, burning a hole in your pockets, seeking substantial professional fees for drafting a patent specification for you. Now that we know about patent specification, it is the time that we introduce to you about Pateomatic. In simple words, Pateomatic is an automated tool that instantaneously provides you the patent specification which is required to file your patent application. Pateomatic seeks specific technical inputs from you and generates as an output, that is, a patent specification for your technical or scientific developments suitable to further proceed in making your patent application. As I already mentioned, it is not at all essential to develop something very high and complicated technical stuff for making a patent application, but you must provide at least a simple solution to any existing technical limitation. Such simple solutions might be effectively found in your research thesis, your existing publications, even your semester assignments, and to mention specifically that the subject matter eligible for making a patent application might even be identified in homeworks or vacation tasks by school-going children. Therefore, you can make a patent application for a research or existing work done, and Pateomatic will convert your technical developments automatically into a patent specification. So, you do not need to find a patent attorney, not even spend a penny to get your patent specification drafted with respect to your technical subject matter. Pateomatic will do it for you absolutely for free. The patent specification that you get will comprise the legal content that goes into a patent specification, namely the background of the invention, description of figures, objective of the invention, summary of the invention, description of the invention, and such necessary content that in a way is fully supported and specific to your technical context. And of course, not to forget that it is fully automated. Pateomatic asks you sequentially specific questions just in the manner your patent attorney would do, and the answers that you provide becomes the content of your patent specification at the appropriate place of the technological document called as the patent specification. Pateomatic guides you, drawing analogy from similar technical contexts so that you are sufficiently enabled to provide the specific answer to a specific question. That way, a lot of time and unnecessary discussions are avoided, and we get the desired output at once, that is, the patent specification. As I told earlier, a patent specification typically requires a background of the invention, objectives and summary of the invention, description of the invention, all of which are made available from your specific answers in the patent specification automatically generated through Pateomatic. This patent specification is completely supported with required technical experimental data to satisfy legal criteria of patent enablement, also satisfying the targeted audience specific to your technical context. This patent specification fulfills all the patentability criteria that is needed to proceed with for finally filing the patent application. We shall know about the basic patentability criteria within a few moments ahead. You also have the provision to allow us to file a patent application at your option as soon as possible without wasting time through online mode. Ultimately, your patent application succeeds to become a granted patent in your favor with the help of our professional expertise. Moving forward, to file a patent application, it is
all right. So we have seen a basic introduction of what we are going to present today. So to begin with, just to give you my introduction, I am a registered patent attorney. My name is Rajarshi Dasgupta, and I have completed my BTech in the year 2008, and then I have done specialization in the intellectual property laws. I'm also a law graduate. I'm a lawyer. I have done bachelor's of law with honors in intellectual property law from IIT Kharagpur from 2008 to 2011, and moreover from the year 2000 early 2010 I had been into training and practice on this field, and from 2011 I am a full-time registered intellectual property attorney. I am a registered patent agent of India. Okay, having introduced myself, just to introduce my field of services, I do serve in the field of intellectual property in the domain of patents, trademarks, copyrights, designs, and other branches of intellectual property. And I'm thankful to the organizers to have organized such a beautiful session today and give me a platform to present myself about okay. So before I proceed, my it is my pleasure to introduce the organizers today, particularly Samanvaya. Samanvaya is a tool. Samanvaya is a information management system providing company, and we generally provide various services including alumni network, digital library, and live events for colleges, schools, institutes, as well as universities. This particular company is an unique platform which provides the opportunity to upgrade its your institutions or any institution going from manual to digital framework and make an everlasting experience and bond between the students, the alumni, and the faculty members and all inmates of an institute. And Right Solutions Consultancy is one of the major HR services providing company in Rajasthan, which offer placement services, soft skill development, personal development, and in the nature of like services, which fulfills the requirement of the corporates to hire skillful resources for themselves. So I'm really thankful to both of these organizing partners, and on behalf of Samanvaya, Right Solutions Consultancy, and Solutions for Your IP, which happens to be my organization, I welcome you all to this session on intellectual property rights and most and most appropriately Pateomatic, which is a tool which I'm going to describe to you in front of you, which will make you sim which will make you simple to draft your patent applications from your technical subject matter. As you can see, in this particular okay, I think I'm audible to everybody. If I'm audible, please post in the chat window. If I'm audible properly, please post in the chat window yes, yes, in front, in the manner of yes or no, if I'm audible properly. Before I proceed directly into the topic, if I'm audible properly, I would just like to have a confirmation from all of you. In the live discussion, please post whether I'm audible or not. Yes, no, yes, no. Please post. I want the session to be engaging. I am getting so many questions. I think I'll be able to answer all the questions of today's discussion. Well, I am not. I'm not getting any responses. I want everybody's response. You have a chat window in front of you. Please just type yes, no. I'm going to take you along the session with your responses, whether you are able to understand or not. Please keep on showing your involvement. Otherwise, this is going to be of no much value addition. Okay, I'm having a few responses. Yes, it's audible. Yes, thank you, thanks a lot. And right now, let us proceed to today's discussion on patents. I have already got a few queries about what is intellectual property rights and how can I what is intellectual property and all these things. That is why I will just first have a basic discussion of what is a patent, okay, and then I will take you slowly to the way you can draft a patent directly. See, I believe in doing, I don't believe in giving in too much of lectures and uh, too much of uh, hearing thing, but I am too much pro in doing things. So that is why I have developed a tool which is called as Pateomatic, and Pateomatic will help you draft your patent applications automatically from your technical subject matter. That is absolutely for free. But to draft a patent application, it's very rightly asked by so many people already present here, that what is intellectual property and how can I take benefit of intellectual property? Why is it relevant for me? Right? So for that matter, I am here to get you introduced to intellectual property first, and then I will take you to the next level of it in very easy and understandable terms. Okay, let me tell you what is intellectual property. In the very beginning, what is intellectual property? Okay, yes, intellectual property is a property. Okay, so let me show you this slide which I have actually prepared just today for yourself before I started this session today. Okay, property, in the very definition of it, we have the word property. So when I say property, you will understand that a property is something immovable. Okay, so if So I think I'm able to correlate. When I say property, you might be thinking of property as such a 2 BHK flat, or your own home, or your car. So these are all the examples of property, right? So same way, intellectual property is also an example of property. Now let us understand, how do you create a property? How do you create a property? I'm going to describe this picture for you. Please be with me for some time, but listen to me carefully. When you purchase a car, you need to register it. But if you purchase a mobile, you need not register it, right? But you have to pay a price. You have to pay a price to purchase a mobile, and that just because purchased, you have purchased the mobile, you have purchased a property, you have to pay a price associated therewith to establish the ownership on that particular property, be it a movable property like a building that you can see here, or be it a immovable property like your car, a mobile, a pen, a laptop, or any nature of things that you buy from. So everything that you buy becomes a property. What is the other way that can become your property? What is the other way that can become your property? Okay, in that case, I would like to hear from you, what is the other way that you can, any idea? Unless buying something, how can you make a property of yourself? Okay, let me tell you. I think the chat window is not, there is a lag. So I don't want a gap in between my presentation. So that's why, let me tell you, property can also be claimed when you create a property. When you create a property, let us get back to historical times. Okay, when somebody established its ground to stay there for some amount of time, it is still there in today's transfer of property laws, in transfer of property act. If you have been residing in a particular place for a minimum period of 12 years and you have not been objected to have stayed there for the past 12 years at the least, and you can establish it through evidence, then that particular ground becomes, not exactly becomes your property, but you establish easementary rights. Like, nobody can block you, restrict you in doing what you have been doing on that piece of ground provided you have been doing that thing for at least 12 years from the date of questioning yourself. Similarly, that means that particular right had been created by that person. Or if we go to the historical times, if we have I mean, there is an immense jungle. Okay, there is jungle, and in one part of a jungle, you make an area, cut it out, cut the trees, make it what stable. You make a hut, and there you start staying. So that particular area you have created for your residence at that particular time, and that's how that property became yours. Okay, today it is not possible. Obviously, it is not possible. I'm telling when. Correct. So in that manner, same way, apart from buying things today also you can create your property. Unfortunately, you cannot create much of immovable property, but you can create intellectual property. Okay, and that's where the term intellectual property begins to start with. Understood? So, and I said you before that property, if it is a big property, if you have purchased this mobile, it's a costly mobile. Okay, but I need not go into a government registration forum to get this registered on my name, to get this mobile registered on my name. Do you agree with me? Correct. I don't have to register my mobile, I don't have to register my laptop. If I purchase a fan or an AC, all these are costly purchases. Through by means of purchase, by means of that invoice, the ownership on that AC, the ownership on that mobile is being transferred from the seller to the buyer, that is to myself. Correct. But I did not register them. So for there are kind of properties, valuable properties, which need not get registered from the government of the country. Okay, but there are some nature of properties which needs to be registered from the government of the country. Why it is needed to be registered from the government of the country? Because there is a possibility of chaos happening if such properties is not being registered. Such as, if I talk in terms of immovable property, if you buy a car or a bike, you have to get it registered from the government to establish the ownership that you have on the thing, that on the car that you have purchased. Unless, even if you have paid the price of that car, if you have purchased an original car, okay, if you have purchased an original car but you have not registered it, nobody will agree that the car belongs to you in today's forum, in today's scenario. Isn't it so? Similarly, if you purchase a 2 or 3 BHK flat or a house, you have to register it from the municipality office to establish that particular house or residence belongs to you and you are the owner. Unless you register such stuff, because there are regulatory laws in India, because there are regulatory laws in force in the country, in the land that you stay, to establish the ownership of your particular property. Otherwise, people will start fighting with each other. People will start claiming that this particular land belongs to me. How the hell did you enter? Right? And in the same way, people will start, if somebody steals your car, people will not agree that the car has been stolen from you and you are the original owner of that car before. That is why All right. So having said that, I am just taking you to okay. Having said that, let me tell you. Similarly, the way you have to register your land, you have to register your car for the purpose of establishing your movable or immovable property. Similarly, you have also to register your intellectual property, because intellectual property, as I've already said you, cannot be seen, cannot be cannot be purchased like others unless it is first created by a creator. So every kind of intellectual property in this slide, I have only demonstrated patents and trademarks, okay, but there are more than these two kinds of intellectual property. Intellectual property, why it is important? The next question is why it is important, intellectual property. Okay, suppose you have an idea, and that idea is okay, let me directly head on to a video that I intend to share with you all. Okay, please, in terms of today's COVID-19 situations, I have something to share with you. Probably you might have got that thing before only, but you might have seen that video before only, but still then I would like to share with you again, and just have a look on it. Just have a look at it.
स्कीम तैयार होती है, मैं आपको दिखाता हूं. हाँ जी, तो आप देखेंगे कि ये मेरी स्टीम तैयार हो गई है और ये स्टीम निकलना शुरू हो गया और काफी दूर तक इसकी नोजल इफेक्ट डालती है. अब आप देखिएगा मैं कैसे सैनिटाइज करता हूं अपनी सब्जियों को. थोड़ा पास आइए मैडम. इतने टेम्परेचर पे और साथ में डिटॉल या कोई भी अल्कोहल डालने से इतने टेम्परेचर पे जब ये स्टीम जाएगा आपकी सब्जियों में, तो मेरे ख्याल से किसी भी सरफेस पे वायरस का बचे रहना नामुमकिन है. ये देखिएगा मैं कैसे अपनी सब्जियों को सैनिटाइज कर रहा हूं. बाद में आप इसे कहीं भी रखिएगा और जब भी आप इसे यूज करेंगे तो धो करके यूज कीजिएगा. और आप क्योंकि मार्केट से इमीडिएट लेके आए हैं तो कहाँ वायरस है ये आप जानते नहीं है. 5 मिनट का काम है अपने कुकर पे, गैस पे, और थोड़ा सा डेटॉल या थोड़ा सा अल्कोहल लेकर के पानी में मिक्स करके और इस तरीके से आप सैनिटाइज कर सकते हैं. आप देखिएगा कितना बेहतरीन तरीके से सैनिटाइज हो रहा है. इसके अलावा आपको मैं दिखाता हूं कि कैसे आप किचन को सैनिटाइज कर सकते हैं. ये देखिए किस तरह से आप किचन को सैनिटाइज कर सकते हैं. आप चाहे तो अपने बर्तनों को सैनिटाइज कर सकते हैं. अपने बर्तनों को सैनिटाइज कर सकते हैं. इससे बेहतर सैनिटाइज करने का तरीका और मिलेगा नहीं. इंस्ट्रूमेंट्स तो बहुत आते हैं पर ये इससे बेहतर तरीका मुझे मिला नहीं जो घर के अंदर अवेलेबल हो और जिसके लिए आपको पैसा खर्च करने की जरूरत नहीं है एडिशनल. तो आप सभी समझ गए होंगे कि थोड़ा दिमाग लगाने से हम लोग कैसे कोरोना से बच सकते हैं. तो मेरी उम्मीद है कि आप मेरे इस टेक्निक को फॉलो करेंगे, अडॉप्ट करेंगे और अपने आप को बचाएंगे, अपने परिवार को बचाएंगे कोरोना से और सदा स्वस्थ रहेंगे. सर्वे भवन्तु सुखिनः, सर्वे सन्तु निरामय, सर्वे भद्राणि पश्यन्तु, मा कश्चित् दुःख भाग् भवेत्.
All right. So I think you must be appreciating the requirement of this particular device in today's world. So this is an idea. This is an idea against a particular problem. The problem is we are unable to sterilize our essential procurement from outside in a better manner, in a convenient manner. Even I face the same problem when I bring outside ration. Today we have the risk of getting infection through the surfaces which had been exposed to the outside environment when it was, we never know when it was present in the stores or when it was in transit from the manufacturing company to the store from where we have purchased it. So for that matter, we have to sterilize. We have to sterilize to be sure that none of us is getting in, is our home members are not getting infected by coronavirus once we purchase something. But it is very much problematic if you dip everything that you bring from outside in water, that particular matter, that particular purchase, suppose an atta packet or a fruit or a edible substance, those things cannot be dipped in water every ways, in soap water every time, right? So we need, if we dip in soap water, I have experienced spoiling of a, I think the atta packet is sealed, but we don't know that these kind of packets have perforations within themselves, so that it does not get spoiled when it is packaged. So it is also a technology. So what I mean to say, technology, the word technology is associated with us uh, very much, very much intricately in our lives, in our lifestyle. Even if we are not a technical graduate, even if we are not engineers, even if we are not studying technology, still we are closely involved with technology day in and day out. Okay, so for example, a lawyer or a accountant also uses a mobile, and mobile is a piece of technology. So what I mean to say, that technology is associated based upon the requirement. What is the requirement today? Requirement is sterilization of such items without water to be free of coronavirus infection, and for that matter this particular device had been created, wherein the property of steam is exploited in a convenient manner within the household settings to sterilize whatever we get from outside, to be assured and ascertain that we are not getting infected from coronavirus, okay, through the surfaces that was exposed before it entered our home. Correct. So this is an idea. Okay, I am not talking about business perspective, but please understand that this is an idea. Okay, today we have coronavirus. In at least for a 2 or 3 decades, we learn the world is changing, the world is ever changing. Okay, today we have this webinar to get in touch with you, from with different people from different corners of the country, sitting from this particular corner where I am sitting. So this technology has evolved so that we cannot physically accumulate in a particular seminar hall to present my seminar today, to my lecture today. Correct. So technology is changing. Similarly, today, due to this coronavirus infection, it has given indication that we might be in requirement of particular sterilization device as an essential item for the coming 2 or 3 decades. Today there is coronavirus infection, tomorrow there can be some other virus infection, or there can be another biohazard. If not a biohazard, some kind of an hazard may come up, and we need prevention for that. Okay, just like we are now busy with developing coronavirus vaccine, we need prevention, and we don't want our lifestyle to be impacted because of some of the other disturbances that come on its way. So similarly, I want to mention that this particular device that he has created, right, that this particular, I don't know this person who has done it, I really appreciate that he has come up with a solution to an existing problem, right? Tomorrow this particular technology can be modified or improved or fine-tuned to develop into a product, maybe a product wherein there may not be a requirement of a pressure cooker, just a simple handhold device, switch it on, have a pipe, and steam comes out, and you sterilize everything in and around you. So this is the generation of an idea. And when you make products out of this technology, right, when you make products out of this technology, you deserve the credit of it. You deserve the credit of it. You deserve the credit of what you have created for the first time, for the benefit of public at large. Don't you think so? Right. So for that matter, for that reason, you need to be, there is a necessity of a particular, um, framework. There is a necessity of a particular framework to to avoid the credit that you deserve. And there is this existing framework known as the intellectual property. What I mean to say that in this video, intellectual property has been created, but benefits of this intellectual property cannot be avoided unless such intellectual property is registered. Unlike other forms of property, as I can show here, registration may not be applicable, but if it is something which has something to do with the harmonization of the society where we stay, or regulation of the people by the country, and all such kinds of properties needs to be registered. And same way, with the additional reason that intellectual property cannot be seen, cannot be touched, it needs to be first registered to say, yes, I have an intellectual property with me, I own an intellectual property. Okay, now let me come to the next topic. What is the reason of intellectual property to be registered? I can start. I don't want to commercialize, I don't want to gain money, I am not so much of money making intent. Why do I make an intellectual property? This video that I have seen from the pressure cooker, steam generating out, and a pipe and with a nozzle, all these things, it is for the convenience, for the benefit of the society. But why do I make money of it? I don't need money of this thing. Okay, you can say like that, you may say like that. Okay, in that case I would say, how will you propagate and spread the message? Okay, WhatsApp is a medium, social media platforms are a medium, but that is not an authenticated medium. That medium does not have the law or enforcement of the country. Okay, what if a medium is there from the government of India who will publish your technology for free, provided you file a patent application on it? Okay, so when you make a patent application, that patent application is published by the government of India, and the country at large is able to understand, see, and take benefit of your invention, of your technology. And the choice is up to you whether you take money out of it or not. But at least that way, people from all over the country, from an authenticated and from a government platform, is able to see what your technology is. So don't you think that is a better resource of spreading your message? Correct? So having said all those things, what I mean to say is, the next topic is the necessity of filing patent applications. Patent applications is a nature of intellectual property that gives you a particular right to claim your ownership of your technical creations. Okay, another way, let me try to explain why is intellectual property, or why is patent important or relevant to you. Okay, in this picture we can see that there is a huge building, and there is a replica of the building below the building as well. Okay, let me try to say it in another manner. We all want to register purchase flat for ourselves in the city that we stay, which might cost 60 lakhs to 1 crore minimum, right? We need our own home, to stay with. We don't want to pay rent. That is the basic aspiration of any corporate employee today, at the minimum, if I'm not wrong. Okay, and we need at least a car. That is what the definition of our happy life. Unfortunately not. Unfortunately not. Let me tell you, unfortunately not. Why? You want to buy a property of a 2 and 3 BHK flat and get involved, get your hands tied up with invisible chains around you, and you become a, let me tell you in a little bit harsh manner, you became a slave of your salary. You became a slave of your salary because you have to bear a loan for the next 20 years. So it is not actually giving you any freedom, rather only giving you a place to stay for the next 20 years, wherein you can claim ownership on that, of course, but subject to the repayment of loan. And in that loan takes much of your lifetime when you are young. You try to work hard, you try to sell your labor in the form of your employment, but what comes in is the pressure of supporting the loan that you have taken for your property. I'm trying to correlate with property because patent is a kind of intellectual property. All right, 40 to 60 lakhs to 1 crore, you get 2 or 3 BHK flat. At the minimum, it may go more higher than that. But what do you get? You get a liability. You buy a liability, and only you can stay in that home. Okay, won't you like to create a building like this, wherein in the ground floor, won't you like to buy a building like this in your life? Don't you aspire to own such a building like this in your life, where in the ground floor you stay and you can give all other floors above you on rent, and you can give such kind of facilities in and around you, and with a particular fencing system, as you can see here, which gives you security. This fencing system gives you security, right? But this is possibly, we think, unimaginable in with respect to our current settings. Okay, and you might say, if I don't have money, this dream is for businessmen who owns lots and lots of money, right? They can avail this particular facility, correct? So in the same if you say so, won't that lets me to ask you the next question. Don't you want to earn money in the same figures? Don't you want, maybe you may not, okay, you don't have money making dreams, okay, let it be. It's not, I'm not completely towards establishing or making you businessman or something like that. I'm not telling anything like that, but what I want to say, what I want to convey is, when you create intellectual property, you facilitate development. And you don't buy liability. You buy, on the other hand, you buy advantages that brings you more and more convenience in terms of money, convenience in terms of being famous, convenience in terms of credit, convenience in terms of lifestyle for the benefit of others. So what I mean to say, it is always better to purchase a big building, to create a big building wherein you can facilitate so many services, wherein you can facilitate so many provisions for the benefit of the public at large, rather than thinking to just have availing a small 2 or 3 BHK flat. Okay, you would say creating such a building, making such a building is of huge money involved in this case. Yes, that money is involved, but let me tell you, intellectual property will help you create that money. Okay, coming to buying a property or registration of your flat, which might take 61 crore, 1 crore amount, that property is an asset to you for your life and for your children, for your next generation. Similarly, intellectual property is an asset that you can avail at the best within 1 lakh to 1.5 lakhs of rupees, and that will free you from the barriers of involved in a loan for the next 20 to 30 years. On the other hand, that will give you opportunities to sell it out, this intellectual property, to outsiders who will make products out of your intellectual property, and you will be benefited out of it in terms of royalty, in terms of credit, and in terms of value proposition, and in terms of economic establishment of your country. Okay, too much of things right now. Let me come to this figure right now. Here we can see a big building has been generated. There is a big building, there is a swimming pool on top of it. I mean, it has a lot of facilities inside, lot of floors within this building. I mean, a very strong building. But now I would like to introduce the functionality of this mirror image of this building that I have just pasted below. And this mirror image is the thing that resembles the patents applications. Why? Because you can understand that this image is a foundation. It's the foundation of a building. It is not like what you see only top. Maybe the foundation of this building, may go even deeper, which is beyond the reach of the graphical representation available to me. This foundation has to be strong so that this building does not fall down, and this foundation is what actually resemble your patents, the technical foundations on which this building is standing, and this building is the ultimate product, which might contain intermediary products in between as well. Each floor, each window, each door are intermediary products. Even these particular recreation facilities can be understood as products. I am trying to define intellectual property in resemblance of our common understanding with an immovable property. Okay, every building, every big apartment has a foundation, and that foundation is the patent applications, is the technologies underlying your product. Okay, and in that case, that products are supported by this foundation, and I'm telling it again, this foundation is your patent applications. Okay, and a patent application has something called as claims. We will see in due course, patent application has something called as claims, and claims is the boundary of this particular fencing. Okay, nobody can enter your boundary unless he is an authorized person, unless he is a resident member of this particular building. Nobody can enter this fence. You are prohibited from entering this fence. So this is a boundary. Similarly, in a patent, there is something called as claims that establish the technical boundaries, technical limitations to what extent your technology can be applied is defined through the claims. Okay, and that claims establish your intellectual property in the form of patent applications, which is supported by the description of that particular technology, which I am relating to as the foundation of this building. Okay, and okay, to establish the requirement of intellectual property rights, establish the requirement and to make you understand about intellectual property rights, we have a children play zone here, which is named as Happy Kids. Okay,
We have a golf and snookers club here, which I have named as Snookers Club. GNOOKERS KERS Snookers Club. We have a gym and a gym here, which I have named as Power Zone. We have a stadium here, which I have named it as Duke's Cricket. It's cricket means combination of cricket and soccer. So I have invented some catchy names, which might resemble the kind of facility provided. Okay, so these names, even there can be a name of this particular apartment, maybe the Brindavan apartment, for example. So these names are the names of your products, and you don't like others to name their products in the same manner you have named them, because you have invested a lot of time and effort and skill to make that product which is founded by your patent applications, and those products has a particular quality to fetch, through which your customer will be having some warranty. Why do you buy Colgate toothpaste? Why don't you buy Meswak? If somebody would buy Meswak, why not Colgate? Okay, or why do you buy a service from why do you rely upon Google more than any other online searching platform? Because over the period of time, based upon their technology, they have established a quality, and that quality is hidden in their names, and therefore these names are also your intellectual property, and therefore to register the names, the provision, the particular method applicable to you is trademarks. So these names are trademarks. Power Zone is a trademark. Okay. Uh, Duke's Creaker is a trademark. Happy Kids is a trademark. Nookers Club is a trademark. And this foundation is your patent applications. And you have the provision to let others inside this boundary. You have the provision to let others inside this boundary and allow them to stay in this building. Innumerable residents can be allowed based upon your will, through which you establish a platform wherein people are taking advantage of your technology, and in return you are getting some benefits, maybe in term of money, in term of royalty, or in term of credits, or in term of some rights that you get. Okay, suppose for example you have, if it is not money, let me try to connect with you in a very more simpler term. If it is not money, you have created this building, and you let somebody stay in this building in one of the flats in return of, and that particular person who comes in to stay in this building, maybe he has taken entire floor. So in that entire floor he owns a airlines company, and in return he gives you the benefit to fly wherever you want, whenever you want, completely for free, because he is staying in your building. So this is the kind of benefit. In other words, there are so many host of benefits if you have intellectual property. So in comparison, just comparing again, if you don't have intellectual property, if you just aspire to make tangible property in your lifetime, you get involved and you get entangled with so many liabilities, along with the benefits which are also there. I'm not telling there are no benefits, but the liabilities are more crucial and gives you tension for the rest of your life. But intellectual property, on the other hand, obviously whenever there is a property, whenever there is a right, there is a liability. You have the liability of such intellectual property, but it is, most of the liabilities are disposed by you when you are creating the property, when you are registering the property, which we will also see going forward. After those liabilities are disposed, that property, intellectual property, is registered on your name, and
you have the right to get benefits out of it, you have the right to monetize on it, you have the right to get famous on it. For example, let me come to the technology right now, and I'll quickly go through the slides and head on to Pateomatic right now. I think I have been understandable, and then I will take the questions, and then I will take the questions. But let me tell you, out of the context, again I am telling you, please go to my YouTube channel. It is Solutions for Your IP. Please get in touch with my channel. Kindly subscribe my channel, and then you will be able to understand intellectual property more out of it. You will be able to understand intellectual property more out of it without complex legal terms. It is purely legal activity. Intellectual property is purely legal activity, and you can either type Pateomatic or you can type solutions numeral 4 URIP to understand intellectual property in more easier terms. Please subscribe to our channel, and I'll be bringing you too many stories in the days forward, wherein I will let you know how small individuals, how unknown individuals have taken benefit of intellectual property to become famous and to become and make a kingdom of their own business in the market share, in the competitive market share. Okay, so please, either you can type Pateomatic or solutions for your IP. You will directly head on to our channel, which I am also posting it. I'm also posting it in the chat window here. Kindly go there and subscribe to our channel. It's a humble request. Okay, let me come to the context again. Patents. Patent, as I said, is a kind of intellectual property right. There are different kind of intellectual property rights. Okay, patent is a kind of intellectual property right, just like other rights which you can see here: freedom, trust, justice, right to freedom, right to justice, rule of law, or right to peace and fraternity, prosperity, right to dignity, right to equality. Similarly, patents is also a right. And that right is actually different from other rights. Okay, these rights are automatically available to you, known as human rights or fundamental rights, which are bestowed upon you being a citizen of our country. Okay, so these kind of rights are available to all, but a patent right is just a right available only to you. I have posted my YouTube link in the discussion. Please okay, so I'm just going through my through the feedback, to the chats that I'm coming. Thank you for appreciating the explanation that I've given. Thanks a lot. At the same time, kindly, if you want to get in touch with me, if you want to be connected, kindly subscribe our YouTube channel. That will really help you immensely in making your lifestyle better. Not only for yourself, for the persons, for the people that you are concerned about, and lot of recognition coming your way. So please stay connected with us. Please stay connected with us. Kindly subscribe to my channel. Coming to the discussion again, I was discussing what is a right, what are other kinds of right. Other kinds of rights are intellectual property, are normal fundamental rights available to us by virtue of obeying the constitution of our country. Okay, being an Indian, those rights are automatically given to us, and the liability of that rights is we have to obey the constitution of our country. As I said, there is always a liability associated with a right. But patents is not a right that is available to you by default. Let me tell you, patent is not a right that is available to you by default. Patents needs to be applied. Why patents need to be applied? Patents need to be applied. Patents need to be applied because that patents, for the property you are creating, that property cannot be seen. That property needs to be registered only. Then only that essence of that right is created. All intellectual property has to be registered. There is an exception. Copyrights need not be registered. The way you write it, the moment you write it, like I have written something here, the basic act of writing is actually the expression of it. Okay, and if I have evidence that I have written it before others at the time of dispute, I am authorized to be bestowed the copyright on it even without registration. But except copyright, all other intellectual properties needs to be registered. For that matter, even trademarks need not be registered. But there lies very high chances that you are copying upon somebody's other trademarks brand names. So therefore, there are so many products. The market is very large today. There are so many options available to customers, right? For that reason, whatever name through which you are selling your product, it is always suggested that you register that right. Otherwise, you are creating a problem for you unknowingly. You are susceptible to be alleged by others. To be infringing upon their brand names. So therefore, if you are selling something or if you are making a product out of your patented technologies, it is always suggested that those products, the names of those products, be registered exclusively on your name in the name of trademarks. Otherwise, even if your technology is registered, you have a security, but you don't have assurance that that security is complete. Okay, so what you do is by creating different intellectual property rights, you are actually expanding this fence. You are actually expanding this fence, not only in the form of claims in a patent application, but claims in the form of your trademarks, claims in the form of your designs, claims in the form of your property, claims in the form of your copyrights, claims in the form of your geographical indications. Every and other intellectual property right, the moment you are registering them, you are creating a fence for your security, and you are enhancing the extent of your claims of your fence. Compared to other intellectual property, if you buy a car, the ownership of your car is limited to the volume and the geographical coordinates to which your car is extending or having its location, right? Means whatever the shape and structure of the car, within that limit only inside the car is your ownership. Whenever you are purchasing a home, within your home only is your ownership, not beyond that. But by way of registering more and more intellectual properties, you are registering your boundaries, you are extending your boundaries beyond limit. That is what another advantage in when for intellectual property against normal property. Okay, having said that, patents is a special right because it will be exclusively given to you and it will not be for others, and for that matter there is a particular mechanism to obtain a patent. There is a particular mechanism to obtain a patent. There are other slides that I'm not going much detail up to. Okay, one thing just because of this coronavirus situation, unfortunately we are having so much layoffs. So I have actually taken some slides from Novelty.com to show you that the see here this is the complete hiring trend of this year for the month of April as against April 2019, April 2020 as against April 2019. There is a drop by 62%. 62% already drop is there of in terms of getting new jobs or layouts from jobs getting cancelled. Okay, so what I mean to say that you want to purchase a home depending upon your salaries, but your salaries are never certain. You are never certain. But if you are an employer, if you create intellectual property and if you start doing business out of your intellectual property, you assure, all right, there are hurdles in the way. Definitely doing business is not so easy game. There is lot of uncomfortable situations that comes your way. You need lot of patience, but once your business is established, obviously your business is going to be established if it is backed up by intellectual property, if it is backed up by patents, if it is backed up by patents, if it is backed up by trademarks. So intellectual property has become a tool to ensure your security if you are doing business. Not only business, if you are in a professional career, if you have in your resume that you have filed a patent application while you have been in your academics, you will not be in this 62% subset. If you will be in the other side of it. You will be in the side of 48% whose job has not been cancelled due to this coronavirus outbreak. Don't you agree with me? So patents is not only for your doing business, patents is also for your professional security. Okay, and out of that I highly encourage at this juncture. I will also ask you that there was a question that all of you might have come across while registering in this particular live session, that what is your particular career interest, whether it is entrepreneurship or whether it is research and academics or a stable job. Let me tell you, job is never stable, and on top of that incremental salary is never guaranteed. Increment in salary is never guaranteed. You might have a respectable job, but neither it is stable, which you think so it is stable. Okay, the intensity of stability in different kind of jobs varies. Some jobs might be relatively more stable, some jobs may not be that stable, and the jobs at the very bottom part of any organization, those jobs are never stable. On the contrary, anybody, even if he is not having a technical background, can file a patent applications. For example, Fungsu Kwangdu from the film Three Idiots, he was not worried whether his degree on BTech, would have been safe or not, whether he will get a job or not, because the degree will come in somebody's other's name. He was worried about only the knowledge that he will gain going to the engineering college. And at the end of the movie, we have I think Chatur Ramalingam, that character. Chatur Ramalingam was always so much particular about having higher scores in academics. Going forward, he also ended up establishing a company, but he comes down to Mr. Fungshuk Wangdu to purchase his patent applications to get license of allowance to use his technologies that you have developed. So that is why I say filing patent applications. Even in that movie we said some 400 patent applications in the name of Fungshuk Wangdu, if you can remember, right? So that is how you increase your safety security by investing a very nominal amount and inculcating the habit of creating intellectual property for you in your daily lives, not only in your professional lives. Okay, we never know the benefit of intellectual property at all, unfortunately, in our current environmental settings, environmental academic settings. So that is why is the intention of our lecture today. While we not only inform you about the intellectual property, we will also enable you to do and file patent applications from your technical domain. And let me tell you, it is not at all a difficult task. It is very much accessible, provided you have the consultation support from us. And that is why I am again telling you, please subscribe to our YouTube channel. Please subscribe to our YouTube channel so that that consultancy is available to you from your queries. I'm going to cover all types of queries that I have come across in my last 10 to 12 years of experience in this domain of intellectual property. And that will be readily available to you. That is why I am telling you that please subscribe to our YouTube channel. I have already posted my YouTube channel link in the description. Please go and subscribe to my YouTube channel hereafter, and you will also get the link of my YouTube channel to the feedback form that I am going to send you very shortly. Okay, as I have said you, there are different kinds of intellectual property, and intellectual property in the domain of applicable in the domain of only science and technology. For the applications of science and technology, there only you can file patents on. Okay, for only applications of science and technology you can file patent applications, not anything else. And today, from hereafter, I would like to restrict my presentation on only patents. Okay, as I have said you, patents is a exclusive right, is a special right, not available to others. There is a particular mechanism to obtain patents. Before going to the particular mechanism to obtain patents, just a little bit more upon the benefits which I have already said about patenting system. But still, since I have a ready-made slide, I would like to establish on it more upon the particular objective things that will give you, that you will be that you can accrue, that will accrue to you by filing patent applications. Patents, as I said you, is going to be published, so you can collaborate with people for the development of the technology. You need not repeat what technology in your particular domain has already been done. Most of our, yes, from my experience I'm telling, most of our PhDs resulting out of this country are doing repetition of what has already been done, because in our current environment academic settings we do not perform a patent search. A patent search is a search from patenting platforms wherein patent applications have been published. And yes, you must have gone through publications, but patents is a combination of publications that give you a more updated version of the technology that you are researching upon. For that matter, patents helps you to collaborate with such people who has already done a research on your similar technical domain. Okay, and then, as I said, you are investing lot of investment in terms of economic resources, effort, skill, brainstorming, hiring of students, hiring of research scholars. So much is going through into the
research. But what is coming out? What is the tool to measure? What is coming out? So patents is that particular tool. Patents is that particular tool to measure the terms of research. Input versus output, and ultimately patents is the medium. You are doing research for 5 to 6 years, 10 years, and there is a huge dump of papers going up, your scientific observations, your laboratory notebooks. If none of us as a technologist want that whatever technology we are doing, we want to restrict it within our laboratories only. We definitely have the underlying intention to utilize that technology for the benefit of others, for the benefit of public at large. And that is why out of your research work, if you have filed at least 2 to 3 patent applications, if you have filed 2 to 3 publications during your research, you can also file 2 to 3 patent applications during your academic work. Please excuse me for a moment. I will be back just a minute. Okay, sorry for the interruption. So so patent is a tool through which you can propagate your technology in a very crisp and precise manner and present it to persons who can scale it up, who can make a product out of it. So that is how patent helps you collaborate with others. Patent is a medium through which your technology comes to the public at large for the benefit of mankind, and ultimately, as I have said you, patents give you ownership on your technology. Patents give you ownership on your technology. If I can show you through my slide here, file till now. For your information, the contribution of technical limitation. Such simple solution. It is a myth that unless you have made something very much complicated, high-end technical stuff, moving further, such patent applications are something that you might learning by inculcating a habit of making new technical developments which is not present before. Yes, it is a myth that unless you have made something very much complicated, high-end technical stuff, you are not eligible to make a patent application. Technical developments which is not present. Research scholar or a student pursuing any technical curriculum, I urge you to file a patent application now and feel the difference while you face interviews for job applications and the preference given to you by your potential employers in the future. Realize the joy of conceptual learning by inculcating a habit of making new technical developments which is not present before. Yes, it is a myth that unless you have made something difference while you face interviews for job applications. 3 scientists have given their lot of hard work to create something inventive and done their publication. Okay, they have published the work. They published their work in 3 different publications. Now what a smart inventor, what a smart scientist over here does, he just combines a new particular thing, new particular element, this particular solution in a conical flask and these publications to make a patented formulation. These scientists have done 80% of the work, maybe 90% of the work, and this scientist also might be looking for the same solution over the same technical domain which these 3 scientists were working upon for the past 10 years. Basically, I'm sorry to say, these are Indian scientists and this is a scientist from US or Europe in general terms. I'm not personalizing, okay? I'm not making a personalized statement, but it is happening in our country. We are doing a lot of great research. We think we are not doing any good research, but unfortunately, that is not true. We are doing great research, but we are not exposed to filing patent applications. We think patent applications is something which is very much sophisticated activity and we have to spend a lot of money, but unfortunately we are not realizing that we are wasting a lot of money in our lifetime in unnecessary things. On the other hand, if I would have filed a patent application, then
tomorrow when a product is coming, this is the product, when a product is coming which involves the technology that I have done, I have to purchase this product from the market despite what I have created. These three scientists had to purchase this product from the market despite despite he being creating the product, but unfortunately he has to purchase it from, because he is the owner of this particular product right now, because he has filed a patent applications. So that's what I mean to say, that patents give you techno legal ownership on your experiments, right? So this is what I am looking forward to from your as a contribution from your end. Please try to file more and more patent applications. How will you file more and more patent applications? That is why I have created this tool for you, which is called as Pateomatic, and this Pateomatic tool I am going to describe to you hereafter within a very short time on the particular device that I have presented in the earlier video that I have shown in this particular presentation, that particular sterilizing device. Okay, we'll go into it, but before we go into it, very simple and crisp explanation of the patenting process. A patent is actually a solution, is a particular application of science and technology, and there has to be a solution to a particular problem, then only that is eligible for filing a patent. Because when you say I have created intellectual property, creation of something has to be for the very first time in the whole world, and that is why it has to be new. Now, how you can ensure that your creation is new? You just have to ensure that you have solved a particular technical problem. So you have solved a technical problem which was unavailable before you created it. That is how, and that is why I have just written this particular word in bigger font, that is new. Okay, so if you have identified a problem to a solution, it automatically becomes new, and new and simple applications of science and technology is patentable. But unfortunately it is not the technical description. Patentable stuff, patenting things, is completely legal activity, and the patent application has to be filed in the form prescribed by the Patent Office of India. I have a question. I have come across different questions wherein I have seen that you are asking how can I file patent application, or where do I file patent application? Yes, patent applications has to be filed in the Patent Office of India, and there is a particular manner through which you have to file a patent application, and that is through a form prescribed by the Patent Office known as the Patent Specification, which includes these particular terms: background of the invention, description of figures, objective of invention, summary of invention, description of invention. If you just see that all the words, all the terminologies sound similar to you, you don't know what is to be written in what particular head. But this is the one where we come into picture as patent attorneys. Every particular head is having some different legal consequence, and therefore there is a legal way to draft a patent specification. That means your technical subject matter needs to be converted into a legal subject matter known as a patent specification, and that is done by a patent attorney. And patent attorney will draft the patent specification in a manner so that it succeeds the patent examination process. Patent examination process is which comes later on filing a patent application, and thereafter this patent is granted. A patent is published two times. Once the patent specification has been generated, it is applied in the patent office, and the patent office publishes the patent application. As I have already said you before, patent publication happens to notify the people that somebody from XYZ company or XYZ name has created this, claims to have created this for the first time, and it is subject to examination by the patent office. If the patent office finds that creation is really new, then you can get a patent upon it as a granted patent publication. Okay, so even granted patent publication, That means that granted patent is also published. Okay, so there is a difference between publication of patent application and a patent grant, which may be taken on later, but please understand that a patent specification is required to successfully overcome the patent examination process, which is a technical and legal expertise area which patent attorneys like me does it for you at a particular price, which is not always, you might feel it is quite expensive, and for that matter I have simplified that particular objective, and that's why I brought to you this tool called as Pateomatic, which will automatically convert your combination of research publication. I see the word combination of your research publications, not only your research publication. See here also there is a combination of research publication. Okay, so that's how there is a combination of research publications which becomes patentable. Okay, so combination of research publication, people say, most of the patent attorneys might opine that if you have published your work you cannot patent it, but me, for my personal advice, I will say it might still become patentable if we have a combination of research publications with some new incorporations through our consultancy, wherein you can also file patent applications of your project works or semester assignments, technical experiments, whatever technical stuff that you have done in your academic course till now. And that particular technology can be benefited, that can be benefited in the form of a patent application if somebody takes it up for commercialization, or even if somebody does not take it up for commercialization, if you have it in your resume, just come back to me and say whether you did get a better job or not, whether you have been appreciated for filing a patent application or not, whether your resume is different from others if you have a patent application number in your resume or not. And it is not difficult at all. That is the myth. It is not difficult at all. It is very easy if you go through the Pateomatic tool, provided you have also subscribed to our YouTube channel to know how to use Pateomatic. And this Pateomatic I will just show you done right away. There is something called as novelty and inventive step in your patent examination process, which is very important, and also enablement. Enablement means your patent specification, this particular patent specification needs to be described in such easy terms so that after the patent is out of your lifetime, after your exclusivity of the patent is over, anybody can reproduce your invention and anybody can reproduce your technical subject matter. Okay, so for that matter your patent should be completely described. You have to write the patent in a manner how you are describing your publications similarly, but not in the exact manner. Okay, and this person is representing the Patent Office of India, who will examine your patent application and will just ascertain whether your patent is new or not. And this newness in terms of legalities is called as novelty and inventive step. Novelty means I will just explain novelty means in very quickly. I'll explain. See, there are 6 individual blocks. There are 6 individual blocks. I am combining these 6 individual blocks to result into this cube. These 2 pictures are the picture of the same cube from 2 different angles that covers the 6 sides of the cube. Now, if I say whether this particular cube is new or not with respect to this individual blocks, please understand one thing. When I'm telling new, I'm asking it with respect to something, what were existing before. These individual blocks were existing before. This particular half maybe jacket, whatever you say, is new to me because this jacket is new in comparison with all the other jackets that I had before. Today I purchased it, so this is new to me, but it is not new to the person who was having it in his shop earlier, right? So newness is from some frame of reference. Newness is from in comparison with a particular frame of reference. So here the frame of reference is these individual blocks. So I have combined these individual blocks and resulted into this cube, and this cube in terms of legality we will see whether it is novel or inventive. So when I have to understand whether it is novel or not, whether novelty is fulfilled or not, we have to understand that there is an individual block, but there is a combination of 6 individual blocks. W is present, but other 5 individual blocks are also present in this cube. So this cube is novel in terms of this individual block. So this particular combination is novel in terms of these individual publications. This particular combination is novel in terms of these individual publications. Similarly, all the other individual blocks, in comparison to all the other individual blocks, this cube is novel. Now, my next question, inventive step. This is also another criteria of adjudicating the newness of your technology. See, don't worry about whether it is new or not. Need not worry much about novelty and inventive step. For you as a researcher, for you as a technical publisher, for you as a technical person, the responsibility of yourself is just to identify whether you have done something, whether you have solved a problem or not, whether you have done a solution to a technical problem or not. If you have done a solution to a technical problem, so your first job is to identify a problem. Okay, as a technical person, your job is to identify a problem, and if you have identified a problem, you will definitely identify a solution if you are obsessed about that problem. That is an assurance from my experience. Okay, so right now my question is inventive step. What is inventive step? Combination of these particular individual blocks should not result upon this cube. So if we see in this particular cube, all the 6 individual blocks are present. So this individual cube might be novel, but they are not inventive, and that is the reason why a patent specification has to be drafted. Again I am telling, see, the combination of these individual blocks result into this cube. Don't you agree, all of you? Combination of these individual blocks combination of these individual blocks, I have given some time for you to grasp it. Combination of these individual blocks results into this particular combination of cube, this particular cube. So this cube, even if novel, is not inventive, so it does not satisfy the criteria of a patent specification. I am just trying to establish the necessity and importance of a patent attorney to draft your technical specification into see here, draft your subject matter into a patent specification which comes at a price and a cost. Okay, but here is the big deal. I am presenting to you Pateomatic, which is completely free of cost, and that will automatically convert your technical subject matter into a patent specification. That will automatically convert your stuff from technical stuff into a patent specification, provided you have identified a problem and a solution to that problem, and it is automated. And here, this particular developing patent specification takes 2 to 3 months of time with to and fro discussion with the scientists, and that is why the patent attorneys charge you probably 50 to 60,000 rupees to make one patent specification. I have done this for you so that Indian academicians does not get demotivated to convert their technical stuff into patent specification if they feel like doing a patent application. If it is not upon their feel like, I would rather say they must file patent applications for the technical development and advancement of the country. being the hub of doing research in the universities and technical institutes. And for that, Pateomatic will help you at your disposal, at your own time, at your own option. Anytime you just answer some basic questions and you have the patent specification automatically, instantaneously, ready-made in your inbox, in your email that you provide. That is why the importance of Pateomatic, and it automatically answers all this. It automatically caters to these needs of different heads of patent specification, which seems to be similar or same in terms of English language, but in terms of legality they are completely different. They are entirely different. And if your patent, even if has something new inside it, even if they are novel, even if they are inventive, still they will not be granted. Your patent will not be granted, and you will lose the intellectual property. Even if you have filed for that intellectual property, you lose the intellectual property if you have not filed the patent in the form of a patent specification. So Pateomatic generates a patent specification. Pateomatic generates a patent specification. Pateomatic generates a patent specification. Please understand, I have, as a feedback question, I have asked so many people after having attended my webinars this simple question: what does Pateomatic generate? The answer is it generates a patent specification which is required to file a patent application. All right. Having said all those things, let us go directly onto the topic of drafting a patent application. For drafting a patent application, you need to answer some questions. You need to answer some questions which you will see in the Pateomatic tool altogether. Okay, but my wish and my humble request is, please subscribe my YouTube channel so that answering to these questions become very easy and simple to you. There is guidance provided from each technical domain so that you can file your patent applications through Pateomatic very easily without any technical professional support in person. Pateomatic is an automated tool. We will definitely get in touch with you after you make a patent specification out of your technical subject matter. We'll definitely get in touch with you, because we will also have the patent specification at your end, the same way you will have it at your own inbox. Then I can take it forward and file the patent application for you in the manner it is supposed to be filed, in much accessible and affordable prices. Okay, correct. So having said that, I will directly go to my YouTube channel. Sorry, not YouTube channel, just a minute. Okay, in the description only I'll get the link. This is the link for Pateomatic. But if you are not so much finding it out from the web is from YouTube might be difficult, so please go to my channel. It is www.solutions 4 numeric 4 qrip.com, solutionsforyourip.com. This is my website, and there you have this thing Pateomatic, right? You have this thing Pateomatic flashing out, right? So you have this Pateomatic. I have just flashed it for a while for everybody of you understand. Go to this solutions for your IP, Pateomatic, click in Pateomatic. Here you have to give your email address. Okay, any email address. Okay, let me write an email. I'm flashing it out. Okay, बड़ा कर रहा हूँ आप लोगों के लिए. Email address I am giving my email address, my personal email address. It will go to any email address that you give. Okay, choose technical domain. One thing, choose technical domain. See here, you have to choose between either biotech, chemical, electronics or mechanical. Biotech, chemical, electronics or mechanical. Why these four email address? Why these four technical domains? It is the law of the land. The patent office will examine only based upon your uh, particular whatever technology you have worked upon. They will categorize based upon only these four branches of technology. So that is why you have to just uh, select whatever is the most appropriate for you. So as I was telling, I would rather try to patent this particular
कि ये मेरी स्टीम तैयार हो गई है और ये स्टीम निकलना शुरू हो गया और काफी दूर तक इसकी नोजल इफेक्ट डालती है. अब आप देखिएगा मैं कैसे सैनिटाइज करता हूँ अपनी सब्जियों को.
I will rather try to
सैनिटाइज करता हूँ अपनी सब्जियों. आप देखेंगे कि ये मेरी स्टीम तैयार हो गई है और ये स्टीम निकलना शुरू हो गया और काफी दूर तक इसकी नोजल इफेक्ट डालती है.
really convinced that it is a solution.
अब आप देखिएगा मैं कैसे सैनिटाइज करता हूँ अपनी सब्जियों को.
device is patent eligible. This particular device is patent eligible. There is a pressure cooker. From the pressure cooker there is a pipe coming out of it. So there are different components, and this pipe is actually solving coming out through a nozzle. Sorry, not pipe. The steam is coming out through a nozzle. So it is a sanitization device. Okay, it is a sanitization device, and it has got so many components. So in Pateomatic you have to give those components, right? And this particular device seems to be in the domain of mechanical to me. So you can just write mechanical. Select mechanical. Okay. Mobile number, I need to give my mobile number. These are all legal criteria you have to provide. And then here is a declaration that we will maintain confidentiality of your technical declaration. Technical disclosure, we will maintain confidentiality. We will not disclose it to anybody else. Okay, but you have to also undertake that you are not disclosing anything which is not developed by you. So you just click I undertake category. My name is RDG. Okay, let it be at least 5 characters. Okay, Rajarshi Dasgupta, and then I am clicking submit. After I click submit, it will land it up to a different for particular domain of biotech tools. Sorry, not biotech, different technical different forms applicable for different domains. So I have selected mechanical. I'll go to mechanical. And there the form is just open. I will just put some information, email address I have again to give it, and then my name. Okay, my name is Rajarshi Dasgupta. Okay, then another declaration. These are all legal requirements, whether you have invented alone or with somebody else, or in the nature of your professional services in a university or a company. So out of these 3 drop down, just select whatever it is. It is just a homemade device. I'll just select self or group research activity outside university, college, institution or company. Okay, here I have to give name and university of your institution or a company. So if you have developed it personally, you have to give the residential address, name of your house or something you can give. Otherwise, most of the times it is not possible to develop a technology without a professional setting. You must have done it in a company, or you must have done in a university, you must have done in a college. So you have to give the name of the institution where have you done it. For example, I'm just writing it here, TIPMS Private Limited. Okay, and then address here I am just writing some address. I can write, just a minute. Address is essential. Okay, let me just try here. Musapet district is Hyderabad, then state is Telangana, pin code I have given. Then I have some explanation here for you ready-made. What kind of inventions can be patented? Any inventions can either be a composition, device, method, or a process. These are the three broad categories of invention in terms of legal language. Okay, so for that matter, I have just explained what can be a composition, what can be a device, what can be a method or a process. So having this description given, you have to just select here what have you invented. So I will say I have invented a device. See the different options available: a composition, a device, a method or a process, a composition and a device both, a composition and a method to prepare the said composition, a device and a process to prepare the said device, a composition, a device and methods to prepare the composition, and a process to prepare the said device. Out of all these things, you can select any one of it, whichever you feel the most appropriate one. Okay, and then you have to see what are the different parts of the device. You have to say what are the different parts of the device. So I have it ready-made written for you. See, patent application, generation of patent application, if you have the things with you, it takes only 10 minutes. Drafting a patent application, it takes only 10 minutes. I have taken the whole of time till now to discuss on what is patents and how the patent should be drafted. But right now I'm just drafting a patent within minutes. Not this one, just a minute. This one I have it in the Word document. I'll just copy and paste, and at the same time I'll just explain you what I'm copying and pasting for the purposes of brevity. Okay, so as I have said you, I'll have to disclose the parts of the device. I have to disclose the parts of the device. So assign a number to part 1. First of all, see there is a picture. I'll just show you a picture of the device. To file a patent application, you have to disclose it in a picture. Okay, if it is a mechanical device, you have to disclose it in a picture. So this is the picture. Okay, and if there is a sterilizer, it has a heating coil, it is a handle, a switch, same concept. Okay, same concept, and different pictures with parts numbered with it. You have to give a part number to each and every part. That is a requirement. That is how it should be. So you can just draw a informal picture. Actually the picture should be good enough, but to start, just to make a initial start, you have to just draw a picture. I encourage you to draw the picture properly. Okay, just like this. See, this is a kind of another patentable stuff. This is how a picture should be, a patentable picture. See, there are different parts, but all the parts are numbered, and therefore in Pateomatic, first you have to give the number of the parts. You have to give the number of the first, number them and then name them. So this is number part 3. Name is stainless steel external layer with vacuum space. Okay, assignment number 3, 4, and then name for this water containing space. Okay, then 5, in part 5 is a handle, and then switch. So assign a number to part 6 is switch, and name of part 6 is a switch. Okay, then name of then assign a number to part 7. I am numbering it as 8, which is a rubber steam disposing unit. Rubber steam disposing unit, and then assign a number to part 8. The part 8 is I am assigning a number 9, and the name of the name of 9 is heat tolerant hose pipe. Okay, and then heat tolerant hose pipe, and then uh, part 9 is number 7. Name part 9 is high pressure steam dispensing nozzle. Finish. So these are the parts of this particular device. These are the parts of this particular device. Whatever we have seen in this video, these are the part of this device. This is how I picturized it. Okay, and then I will have to say what is the problem that I have identified, what is the solution that I have given. I have to say that in a very easy terms. Okay, fine. There are other parts can be given. If it is not applicable to you, just forget about it. Just go down, and here it is important that you have to upload a figure if we have assigned a number and parts. Okay, so you have to upload a figure. Let me go to the figure, just upload it. It will automatically come into patent specification. Upload. Okay, and then it is also important for me that I name the figure. If you cannot explain, you can just name the figure. The figure name is A sterilization. Just A, not you have to say the, here the, because you are particularizing the figure, the sterilization device of the present invention. Okay, then there are other figures that can be added, not required. Just go down, here you have to answer if you have to say how did you develop the device. You have to just upload the process of connecting each and every part to that device, collecting the particular parts, individual parts here. Okay, collecting these individual parts and how these individual parts. Just a minute. So these parts you have to say how did you connect with each other. That is what I have not that I don't have that explanation with me. Just mention in this answer. If your invention is other than a device, or even if it is a device, because there is a process involved, okay, then establish the process step. You can write the process here in your simple terms, however you feel convenient. Then it is an important question: how constituent components of a composition or a device interact with each other to produce the overall beneficial result. So here I have written it for myself. I'll just do a simple paste copy and paste activity. See here, the steam is generated in the steamer when the power supply is switched on, which is then passed on to the steam dispensing unit 8, and the steam traverses the hose pipe, which is then forced out with a high pressure nozzle. And see the part numbers, I have just named it here as well, the part numbers. Okay, so just copy and paste it here. Just copy and paste it here. This is how the interaction between each and every component of my device takes. And the next question is, what is the basis of your invention? The next question is, what is the basis of your invention? So I am just telling that this particular basis of invention, any particular invention, any particular solution of a technical problem is having an underlying scientific principle through it, acting behind it. So it is your responsibility to disclose that scientific principle while filing the patent application. So I am giving this explanation that how a pressure cooker works to generate a steam. Okay, how a pressure cooker works to generate a steam. For that matter, I will just say it is just an exploitation of the basic gas law equation, which is a combination of Boyle's and Charles' law, wherein pressure is directly directly proportional to temperature. If pressure increases, temperature increases quickly and within a closed setting. That is what I have just explained it here. So this explanation as a technical person has to be coming from you. And this is just the explanation of what I have said. PV is equal to nRT, pressure increases, so temperature increases, so it generates steam, and steam has a formula. Steam has a capacity to steam has a capacity to uh, steam has a capacity to produce to sanitize particular objects, and therefore that is the basis of your invention. Okay, then that is provide technical experiments performed to establish that your invention works. Now you have to prove that what you are claiming. You are claiming that you have invented a sterilization device. You are claiming that you have invented a sterilization device. So does your sterilization device is actually sterilizing or not? How will you measure it? So that is the technical experiments. I can say, just to explain, see, I have brought an atta packet. So I am first saying that if I am sterilizing an atta packet with a sanitizer, the atta packet is getting spoiled. The texture and edibility of atta is spoiled because of the alcohol penetrates the pores of the packet. If you wash the atta packet, still then the water gets inside into the packet and it spoils the atta. But if you have sterilized with this particular atta packet, this particular present invention device, then you have got complete sterilization without affecting the texture and edibility of atta packet. Just pay attention here. Here also you are emphasizing on a comparative experimentation to establish your inventive step. Comparison with existing sanitizing devices or sanitizers. These are the sanitizer. Okay, if you are sanitizing with the sanitizer, it is spoiling the thing, but if you are sanitizing with this present device, it is not spoiling the thing. Second experiment is proof of sterilization. How can you prove that it is sterilizing? So here, before sterilizing an object in a sheet of paper, we can count the microbial population, which might be more than 2 million colony forming units per parts per million. But after sterilizing with this device, it is less than 0.001 colony forming units parts per million. So that is how again you are establishing that your invention is working. So what are the technical experiments that we have done is essential to be given. It's essential to be given in Pateomatic. This is just a short explanation of how to establish what I am claiming right now. Okay, for you can directly, here I am just copy pasting it. You see how finally it will come in the patent specification that is going to be generated. But if you don't want to, here I have copy pasted. If you don't want to copy paste, just keep a file ready of your technical subject matter. Just add file, just like a MS Word document, and then you are done. You don't have to type it again. Just add it here, and then the rest are very simple questions, just simple copy pasting activity. Title of your invention. Give the title whatever you feel like. Give the title whatever you feel like. I will just write a sterilization device. A sterilization device. Then here I have to give some prior art. This prior art means what sterilization devices were existing before me for the same solution, for the same problem. So I can say that there are other sterilization devices which I'll establish the figures again because it is just a representation of Pateomatic. In your uh, in your subject matter, you can just upload the technical publications, or you can just copy and paste the abstracts of those technical publications in the place provided. Just copy and paste, or you can establish the problem through subjective writing. The choice is up to you. Okay, but you definitely have to give what was pre-existing before your invention, because legally your invention is going to be accrued to you, will be going to be benefited, will be given to you the credit of your invention only on the basis of a comparison of what was existing before for the same technical problem in the same technical area. So here I will establish some prior arts. What are the other prior technical devices? Okay, so see this, these were the earlier earlier sterilizing devices which were not possible to solve the particular technical problem. The problem is to sterilize household utensils, to sterilize the ration or the procurement of essential objects that have taken from outside without spoiling them. These particular devices cannot give me the solution even if they are sterilization devices. Okay, my job is almost done. Then I have to give the technical branch of my invention. I have given, these are all one word or maximum 2 to 3 sentences answer. Okay, so technical branch is mechanical. Technical subject is application of steam for the purpose of easy, I'll just say easy sanitization. Specific application. Okay, technical subject, you can say it may relate to fluid thermodynamics if I'm not wrong, right? Just just within one word. If you write more, it will show an error message. Just one word, just put it here. It is a technical subject of your invention is depend on the subject of fluid thermodynamics, then application of steam and for the purpose of easy sanitization. Okay, this is the specific application. Okay, then problem, very important. You have to disclose the problems. All the other fields were optional, but problem is important. As I said, you have to first identify a problem to be eligible to file a patent application. See, problem today here is coronavirus is currently a global pandemic. Coronavirus today is a global pandemic, and there is high risk of susceptibility of infection through contaminated surfaces. Okay, just copying. This is my problem 1. Pasting here. Then solution. Steam has the capacity to sterilize any contaminated surface. This is solution to problem 1. These are essential answers you have to provide definitely. Then problem number 2. Although there is COVID-19 pandemic, procuring household essential items is still inevitable for sustenance of life. But such essential items are exposed to the outside environment before they are brought to home. So such essentials are required to be sterilized as well. That means even if there is a pandemic, we cannot avoid buying household items, buying essential items. So this is the problem, that even if you buy household items, they have the risk of infection rising from those particular surfaces which were on the things that were exposed to the environment earlier. So right now the solution is presently invented device enables sterilization of such essential items which has been procured from outside easily and with assurance of safety. Copying and pasting. Last problem, it is a requirement of Pateomatic that you must say at least three problems. Third problem is present devices or methods of compositions available for sterilization are not possible to sterilize specific pockets, packets and goods which become spoiled if exposed to sanitization compositions or if washed with water. This is a problem. Okay, you have to objectively tell the problem. You cannot write more than 2 to 3 sentences. If I write more than 2 to 3 sentences, it has a particular limit. Okay, it will show you an error message here. So the problem I have said solution is the device of the present invention completely addresses the present concerns and is capable to ensure complete sterilization without adversely affecting the shelf life or the inherent nature of the goods or essential items required for daily life. The language of drafting these answers is the language of answering the language of these answers might be little bit complex, as the way not complex, maybe difficult for you to draft the way I have drafted. I request you to draft in a manner most easily explainable from your own terms, for your own terms, in terms of your own language. So don't avoid the complexity of the language or the ornamental aspects of the language that you are explaining. Just explain what is asked for. That is important. If you don't explain or if you don't provide the required answers, you cannot develop the patent application. Last, other advantages. The device of the present invention may also be used for sterilizing any household goods which are also exposed to environment for longer amount of time, thereby ensuring safety from COVID-19 pandemic. It's not only for any the goods that is coming from outside, it is applicable for any other goods, so that the entire environment in and around you is safe. Great. Just other advantages pasted. Last part of it, again a legal requirement. Today is 30 May 2020. I have drafted this patent application. The time is 13:14 p.m. Okay, now it will be shown to you how it comes to your patent. I have submitted it. Pateomatic is over. We will see how this patent is sent to my inbox, the email ID that I have given before. See here, it has already come. It has already come. Pateomatic has sent you your automated patent specification. I don't know, just it is hanged a little bit. Okay, you can see here Pateomatic, your automated patent specification. Here it is in your inbox and with the attached file. This is the attached file, and this is how a patent application should be. Patent application in particular form with applicant name, nationality, address, everything required, and the title sterilization device, a sterilization device. Okay, the spelling is wrong anyways. Fine. Then the field of invention. The present invention relates to the field of mechanical engineering. More particularly, the present invention relates to the field of fluid thermodynamics. Exemplarily, the present invention relates to the field of application of steam for the purpose of easy sanitization. Background, in the background part, prior arts, if I would have given or attached, it might have come there, but since there are no back answer given, so this is empty. Similarly, figure 1, I have an explanation of the sterilization device of the present invention, and the figure 1 is described here. The present invention discloses a device comprising one heating coil, two mantle, stainless steel, external layer with vacuum space, water containing space. All the parts of the device is explained here, and why it has been created. The objects of the invention are present here. Okay, the solutions to the problems is the objective. One objective of the invention is to fulfill the need of coronavirus is currently a global pandemic. There is high risk of susceptibility of infection to contaminated surfaces. Whatever you have given, they have come and sat into the legal places they are supposed to sit at. And the explanation to the invention is there. Steam and how they are interacting with each part. Steam is generated in the steamer. Here, there will be a steamer. Yes. When the power supply not shown is switched on, which is passed on to the steam dispensing unit 8. 8 is the number of that part, and the steam traverses to hose pipe 9, which is then forced with the pressurizing nozzle 7, with high pressure. So this is how it is working, and this is the scientific explanation how it is working. That is the basis of the invention, the basic gas law. Okay. And then these are the technical experiments. See, example 1, sterilization with sanitizer versus the device of the present invention. So it has come where the experiment has come. Okay, and then the proof of sterilization is there. Before, how much was there, after, how much is there. Some if I open it in the MS Word, then it will show in the particular table format as well. And the advantages of the invention. Advantages are all the solutions that you have given. And then this is the figure available. This is the figure available in the patent specification, and these are the prior arts available, because this particular figure, this particular invention is going to be examined with respect to these prior arts. So this is how a patent specification is drafted, and this will be the beginning to file your patent application, which is 80% of the work done. From here, we will take it up and file it at the patent office. So here, this is the end of my presentation. I am done with it today. Maybe I will take some of the I'm again requesting all of you to I'm again asking everybody to please subscribe my YouTube channel. Kindly subscribe my YouTube channel. If you want a certificate, you will have to subscribe to my YouTube channel. That is an unsaid condition, unsaid criteria. Unless you want a certificate, you won't get a. Unless you subscribe to my YouTube channel, you won't get a certificate. So please subscribe to my YouTube channel for your benefit, so that you stay connected, and you are able to file more and more patent applications in your professional career. I'm posting my YouTube link to everybody. The YouTube link will be sent to your emails as well. Please do not delay. Please do not delay. See again, actually I'm getting the uh, I'm getting the query that when you will get certificates. Sir, please understand we have more than 3,000 registrations, and sending the certificates takes time. Moreover, certificate is just a piece of paper. From this lecture, what I want you all to take away is to become motivated to convert your technical research, whatever have you done still now, to at least one patent specification through Pateomatic. Whether we will file the patent application or not is the next thing, but at least try to do one Pateomatic exercise that will change the way you look at things, that will change the way you have approached technologies till now in your life, that will also change the life you are going to have after you have done a Pateomatic submission. It is really encouraging to uh, get so number of Pateomatic submissions after I have given this particular lecture to all of you without any benefit from my end, let me tell you. So that is why I'm again just requesting you, please subscribe to my YouTube channel. Please subscribe to my YouTube channel. That is the only thing that I am looking forward to you, so that you keep yourself updated from a very uninformed topic, that is intellectual property, and that comes to you through my YouTube channel in very easy and understandable terms. Otherwise, you spend on reading on it, you get confused, and start developing an idea that patents is something very much inaccessible, which is not true. Let me tell you, Pateomatic, the motive of myself to make Pateomatic is just for Indian scholars, research scholars, to convert patent applications, to convert patent applications, to convert your technical subject matter into your patent applications. Certificate will definitely be given to you. Please don't worry about certificate telling you repeatedly. Please, good question. I have a question here, whether Pateomatic is available on Google app. The app is coming very shortly to you. An app is under development right now. It is available through the tool in the Google only that I showed you. Go to my website, click on Pateomatic, and Pateomatic is available at your disposal. I'll take some questions today. Right now we have, okay, Mr. Lavish Raheja is telling us that not Lavish Raheja, Mr. Miss, I don't know. Anyways, the question is it possible to patent an educational model? Is it possible to patent an educational model? See, every new thing that you create is able to be protected through intellectual property, either through patents, trademarks, copyrights, or whatever it is, but you can afford protection. So if you have a new model, if you have a solution to a problem, please do it under Pateomatic. Analogize the questions and answer it accordingly. Go and look into my videos. That videos will be automatically connected to my Pateomatic as well. You'll find the videos in Pateomatic, and you can understand what should I answer. Possibly the educational model is not able to be patented, but if you do a Pateomatic exercise, I will be able to understand what have you done, what have you done, so that I can tell you which particular domain of intellectual property can it be protected. Okay, other questions. What is the time duration? What is the time duration of this lecture? The lecture is already over, sir, so it's up to you.
What are the other questions? I'll just have a look around. What are the other questions? Okay, I have so many questions. Chandana, information regarding examples of patent in agriculture is required. Information regarding the examples of patent agriculture is required. Examples of patent in agriculture. Madam Chandana, I would just request you to do Pateomatic and examples. I will give you examples based upon your particular technical disclosure. Without I have your technical disclosure, I cannot give you examples of already filed patents. But nonetheless, in my YouTube channel, I have Pateomatic, different videos for different Pateomatic. I am pasting my YouTube link again. Please go to my YouTube link. Please subscribe to my YouTube channel. I have posted the link once again. Please subscribe to my YouTube channel. Okay. So there in my YouTube channel, you will find different videos of each particular domain, technical domains. See here, different videos of see here. If you just write Pateomatic in biotechnology, you will get, just write Pateomatic in biotechnology. So see here, Pateomatic free self-automated patent application drafting by startups and universities and academicians. Right? So here you have for biotech domain, how to file patent specific by self provisional patent specification drafting in biotech domain. Okay, then you have for mechanical domain, then you have for chemistry domain. Okay, so for each particular domain you have a separate video, and more such videos are going to come. That is why I'm telling you all, please subscribe to my YouTube channel. I don't see subscriptions happening, but in my other lectures, automatic subscription goes up when I'm presenting my stuff. So but here I am not seeing things to happen like that. Therefore I'm pasting my YouTube link time and again. Please go and subscribe to my YouTube channel right away, kindly, for your benefit, to uphold to uplift your professional careers by way of filing patent applications. You must be going for a job interview tomorrow, and there if you say I have filed a patent, you see the kind of difference, the kind of difference in attention you get from your potential employers. For universities, the rankings of the university, the intellectual capital of the universities goes up if they have more and more patent applications to their credit, and they will have more placements. Companies will automatically come to your university for getting placed, for taking people out of your college, because the assumption of a good university or good technical institute is very much reflected in the number of patents that you have filed. And it is not necessary that only a research scholar has to file a patent application. Even a student can file a patent application. Even a laboratory boy, laboratory assistant can also file a patent application on his name. There is no academic qualification as a criteria to file a patent application. Only the knowledge is important. That is why you have to establish that you have knowledge, you have competitive advantage by saying that I am a patent applicant, I am an inventor of a patent application. Okay, Mr. Vipin Tiwari says, how can we decide whether our work deserves a patent? What should be the criteria? Sir, Dr. Vipin, that is what I want to say. If you have done something new, you feel you have done something new. Actually, each and every technical work deserves a patent, I would say. Each and every technical work deserves a patent. Go to Pateomatic, answer the questions. First of all, answer what was the problem. Why have you done this? In other words, why have you done your research in your domain? What was the motive behind doing the research experiments that you have conducted? Try to tell them as a that is the problem, that is the problem, and just that problem is reflected in the patent specification. Everything is patentable for me. Just do Pateomatic and I will make it patentable, and so that you have a commercial benefit, professional benefit, or technical benefit, whatever you say should be coming in. Okay. Okay, Dr. Narendra Kumar Agarwal says, can you let me know the government fee to register your trademark? Trademark, although not very much related to this topic, but let me answer your question. The government fee is rupees 9,000 for a company, rupees 4,500 for an individual or an MSME or a startup. I will be happy to file the trademark application for you, Dr. Narendra Kumar Agarwal. You can get in touch with me hereafter, or I will get in touch with you. What are the difference between trademarks and agmark? Very nice question. Really appreciate. What are the difference between trademarks and agmarks? Agmark is also a trademark. Agmark is also a trademark because agmark is a collective mark under the Trademarks Act. The nature of the mark, agmark, is something different where it establishes a regulatory satisfaction from the government of the country, and only the government like Ayush, Agmark, or DCGI validation, WHO pre-qualified, all these are please all these are regulatory marks, which is also a kind of a trademark, not available to everybody. Not available to everybody. There is a particular criteria of satisfying certification marks and the nature of your mark. So ag mark is a government mark, so that is the difference. It is also a kind of a trademark. It is a certification mark. Okay, then what are the other questions that I have? Just let me see. For filing patent in electronics, it required to take permission of use standard electronics component. See, permission if required will be governed by a different branch of law. I don't know what electronic component are you using. If there is safety measures associated and you have to qualify some safety measures, then you have to do it. Being a person from the technical domain, you should be having the idea on it. Otherwise, we will look for the particular regulatory laws to use a particular electronic device before it is experimented on. So in general, for filing patent applications, you need not take any prior approval from any other unless it is a patent application using a biological material, biological microorganism, or a biological sample, wherein you have to take a permission from the National Biodiversity Authority. A different ball game altogether. Let us not go deep into it. But the answer in general to this question is no. No permission for using an electronic component for filing a patent is required. Dr. Patil, Dr. Suhas Patil. How can I patent my software? Dr. Narendra Kumar Agarwal says, how can I patent my software? How can I patent a software? Please do Pateomatic, sir. Before that, try to understand the questions, answer it, let your patent specification generated, then we will file the patent application for you. Okay. How much time does it take to get a patent? Very good question, Dr. Satishla TN. Thank you for this question. it takes almost 3 to 4 years time to get a patent application, but your rights on the patent application starts from the date when you have filed the patent application. That is from the very first day you have filed the patent application, your rights will start provided you get the grant of the patent application. Because it is a technical activity, because it is a legal activity, because there are so many patents filed day by day, so examination process of a patent begins. After a while, after it is published, patenting procedure I have not covered, it is another detailed video. So there, if you want to I may take a separate lecture on it, but for that, to take this entire legal process, it takes at least 3 to 4 years of time. Maybe it is going to be shortened in the days to come, but it will take still then minimum 2 to 3 years of time to get a patent granted on the date of your patent application. Okay, then okay. Dr. Vipin Tiwari says intellectual property can only be developed, not created. If you have understood me correctly, development and creation means the same thing here. Intellectual property should be done for the first time, and that is what I say it as creation. Please subscribe to my YouTube channel, sir. I am not seeing subscriptions happening at all. I am not seeing subscriptions happening at all like other sessions. Please subscribe to my YouTube channel if you want to get a certificate for this lecture. Any other questions? I want out you told that mobile, laptop or anything related to price, there is no need to register, but the product related to company, that company must have a patent on that item. Yes, Madam Reddy Sai Vindhya Sri, he says, I have one that the product he is purchasing might have a patent on them. Exactly, they must be having a patent on them. But that is why once he has sold the thing to you, the right on the particular thing is over. So you cannot own their patent. The ownership of the object is coming to you, but the ownership of the technology still remains to the one who is having the patent. Okay, if you have bought an AC, that AC is a product which is patent protected. That means you cannot again resell the same product. Correct? So unless the selling is happening, what is the reason of, what is the purpose of making a product? So what I meant to say is registration of that product, registration of a product that AC belongs to you, that laptop belongs to you is not necessary. But when you purchase a car, even that car, a car contains innumerable patented stuff. But that car, the registration of a car has your name on it if you have purchased it. Okay, so that's what I meant, that intellectual property is created through registrations only, because there is no physical appearance of your intellectual property. That's what I meant. Okay. Minimum time to file a patent application. Minimum file, Dr. Aparna says, what is the minimum time to file patent? Minimum time is the minimum time that you take. If you do Pateomatic submission properly, we will file the patent application in 1 day. In 1 day, exactly in 1 day. So you provide your patent application, Pateomatic submission as soon as possible, Madam Aparna. Any other questions? I don't think. What are the difference between trademarks and agmark? I have answered. And then there is any link to subscribe your channel. Dr. Minakshi, I have given Can any innovative idea can be patented? Acha, for subscription, I am just pasting my link again. YouTube link I am pasting repeatedly. Please subscribe to that link as soon as possible. Okay. Then, can any innovative idea be patented? Dr. Sanjeev Kumar Gupta asks. So, thank you, Dr. Sanjeev, for asking that question. Yes, an innovative idea can be patented. Please fill your idea in the nature of patentomatic submission as soon as possible. Yes, the idea can be patented. I don't mind saying that, provided that within a time of 1 year of making the patentomatic submission and filing your first application known as the provisional patent application, within 1 year you have to substantiate your idea doing technical experiments that supports your idea and claiming and establishing that your idea is working the way you are working, the way you want it to work. Okay, for statistical forecasting model we can do patent for that. Yes madam, you can do patent for that, but please do pateomatic submissions. For me, if you ask, can I file a patent? I will say, yes, you can file a patent for anything or everything. The thing is not patents, but there might be different kind of intellectual property available for your protection, whether it is patents, trademarks, copyrights, designs, or whatever it is. Okay, so statistical forecasting model is actually not patentable. Let me tell you, to be very frank enough, be true enough. But once you disclose your idea, once you disclose your experiments, once you disclose what model are you talking about, maybe there may be some patentable stuff lying hidden into it, which is our job to dig it out and afford you the protection that you deserve in the form of patents or any other kind of intellectual property. Lavish Raja asks, can published research be patented? Yes, published research can be patented. As I showed you in my video, this particular, I mean, publication 1, 2, 3 are already published, and another scientist gets something, a new solution, includes them into the published items and makes a new composition. What I mean to say, try converting your published item into a patentomatic submission. Then allow us to provide you the advice and suggestions to make it patent eligible, even if you have published it. Therefore, please do patentomatic submission first. Please do patentomatic submission first. That is what I intend to tell you. Please do patentomatic submission first from your existing technical research that you have already done in your lifetime. Okay, then any other questions? My contact details, you will get email from me, sir. My contact details is, you can note it down, Dr. Sanjeev Kumar Gupta. It is 99081833072. You can directly mail it to me, or if you do a patentomatic submission, you will automatically get my email ID. I will reply to that, or you can directly send me email ID, or in my website I have my contact here. This is my contact. You can anytime send email at corporateconsultants@solutionsforyourip.com or rdg@solutionsforyourip.com for your I'm just writing it here, rdg This is my email ID. Please email me for anything. My phone number and my email ID
is presented here. Anytime you can get in touch with me. Anytime. So this is my email ID and contact details. You can call me anytime. Okay. Please subscribe to my YouTube channel. First of all, please subscribe to my YouTube channel. That is what I am requesting you. Please subscribe to my YouTube channel as much as soon as possible. Okay, let me go through some other patent in electronics. I think I have answered all the questions that have come. Thank you once again. At the end, I thank the organizers Samanvaya and Right Solutions Consultancy, and on behalf of on behalf of Solutions for Your Intellectual Property, on behalf of Pateomatic, I wish you all the best for your personal development, for your for you to grow more and more in your life. Stay safe, stay healthy, and thanks a lot for attending this webinar. Please, please, please go and subscribe my YouTube channel. Thank you once again. Bye-bye. अच्छा जब जाएगा